Now, what happens if you have a will that doesn't have some of these requirements, such as a codicil that I've been dealing with most recently, where the codicil does not have self-proving affidavits, and as far as we can tell, the witnesses no longer are alive, and it's contested in any event? Well, then you have to have a judicial hearing. All hearings will be conducted before the Superior Court, the Chancery Division, probate part. Even when they're uncontested, if it doesn't meet the requirements that we just went through for a will that is valid on its face. For example, a holographic will, which in New York is called a non-cupative will, is something that is in the testator's handwriting. Doesn't all have to be in the testator's handwriting. The signature and material provisions have to be. Witnesses are not necessary, although you have to establish that it was, in fact, the signature and the handwriting of the decedent. New Jersey also recognizes as a will any writing that was intended by the decedent to be his will, even if it has none of the other indicia of a will. It doesn't have witnesses, it doesn't say this is my last will, but if the proponents of the document that it was the decedent's last will can show by clear and convincing evidence, which is a higher standard than more likely than not, if they can show that it reflects the testator's testamentary intent, even if unsigned, unwitnessed, at least in theory, the probate part will accept such a writing as if it were the last will.